Internationalizing African Customary Law Arbitration in the world legal scene, dismantling obstacles, embracing prospects. This promises to be a topic that holds immense significance for the legal community, both within Africa and globally. His insights and extensive research underscore the importance of integrating African customary law into broader international arbitration framework. His work not only highlights the rich legal traditions of Africa, but also advocates for a more inclusive and diverse global legal landscape. As we will listen to him today, we are reminded of the critical role that academia plays in bridging cultural and legal divides, fostering understanding and promoting justice. Professor Chukwuemierie's dedication to his field should inspire us all to continue striving for excellence and innovations in our personal endeavors. Let us also congratulate him for this milestone achievement. We express our deepest gratitude to him for his invaluable contribution to legal scholarship. May your work, sir, continue to inspire and pave the way for a more integrated and equitable world legal order. Thank you very much.
Please, let's appreciate our Pro-Chancellor again. An important aspect of this 100th inaugural lecture celebration is the cake you're just seeing. So it's my pleasure to invite for the cutting of the cake, my lords, the former CJN, who will be accompanied by the Pro-Chancellor, the Vice-Chancellor, Emeritus Professor Makri, the IMSU Vice-Chancellor, the OCJ or Culture SAN will also join them in the cutting of the cake. The former Vice-Chancellors and former Deputy Vice-Chancellors will also join in the cutting of the cake. The cutting of the cake will be moderated by our acting registrar, Mrs. IBS Harry. Yes.
Distinguished invitees, the retired Chief Justice, and all other dignitaries here present. This cake represents the colors, it has the colors of the university, and it equally represents the 100th inaugural lecture of our university. And we're happy to have you in our midst. We're going to mention the name of our great university and then cut the cake. Please, can we all place our hands towards the cake? We're many, so we'll just place our hands towards the cake. So at the count of 3, we'll all say, Rivers State University, and we'll cut the cake. Let's go, please. Rivers State University. Thank you very much.
congratulations to our Vice Chancellor and the university. Please, can we appreciate our university? My Lord, the Vice Chancellor, please permit me to recognize His Excellency Dr. Peter Mba, Governor of Enugu State, ably represented by the Special Advisor to the Governor on Legal Matters, Dr. Osinachi Nnajeze. Please, can we see you, sir? You're welcome, sir. Thank you, the Rep, Governor of Enugu State. Thanks for coming. The Vice Chancellor, sir, it's my pleasure now to invite the University Orator, Professor Isaac Zebo BP, for the citation.
Dear Pro-Chancellor, Honorable Justice Mary Peter Odele, ably represented by a member of the Governing Council, Barrister Dr. Briggs, President of FIDA, our Vice Chancellor, please permit me to stand on the already established protocol. Professor Andrew I. Chukwuemerie, son, fellow, Chartered Institute of Arbitration, UK, is a professor of commercial law of this great university. He obtained his LLB honors from the University of Maiduguri in 1988. He obtained his BL from the Nigerian Law School, Lagos, and was called to the bar in the same year. He later obtained his LLM from the University of Lagos. While lecturing at the Abia State University, he served as the head of 2 departments and in several Senate committees. He was the pioneer head of the postgraduate school of the Faculty of Law, Ebonyi State University. In his teaching career, he worked towards achieving the feat of his mentor of becoming a professor within record time, which he did in 2005. He became a senior advocate of Nigeria in 2009 and was sworn in 2010. Professor Chukwuemerie son has to his credit about 119 publications, among which are 5 texts and 20 chapters in other books. Many of these publications are on topical areas of the law, dedicated to charting new areas and routes for the law, pointing the law to the way it ought to be for the good of the society, making the law much more of an instrument of effective social engineering, like his principal, the cerebral roscoe pond. For instance, in his first article, published whilst not in the academia, Stay of Court Proceedings, Pending Arbitration in Nigerian Law, 13 Journal of International Arbitration, 1996, 119 Switzerland, has, together with the efforts of other persons, shaped the law into removing the troublesome conflict between sections 4 and 5 of the old Arbitration and Conciliation Act 1990. The Arbitration and Mediation Act 2023 contains a workable situation under section 5, doing away with the former. His work, International Commercial Arbitration and Third-Party Interests, a call for urgent reform, published in Honorable Justice Ifeanyichukwu, edited, Contemporary Issues in Public, International and Comparative Law, Essays in Honor of Professor Okeke, available at this site, better the adoption of the recognition of third party or the third party proceedings as it were in arbitration in Nigeria, now in section 39 and 40 of the Arbitration and Mediation Act 2023. Under publication, alternative dispute resolution methods as frameworks for bank debt recovery in the post-consolidation era address the recovery of bank debts after the consolidation of banks era, which had not existed before. The list is continuous, as will be seen in today's inaugural lecture. He is a lecturer and a teacher of teachers. His greatest area of strength is in international commercial arbitration. in which he has done extensive work and traveled around a lot. Arbitration has helped him a lot. He is a fellow of the Chartered Institute of Arbitrators, London, fellow of the Institute of Construction Industry Arbitrators, Nigeria, and belongs to such other arbitration bodies as the ICC Commission on Arbitration and Alternative Dispute Resolutions, where he is a national delegate to the Global Commission on Arbitration. International Council for International Commercial Arbitration, ICCA, Lagos Court of Arbitration, Lagos. He is an arbitrator and a mediator, World International Property Organization, and Switzerland. He is member of Advocates International and Society for Corporate Governance, Nigeria. He has traveled vastly, delivering seminar and workshop papers, principally on arbitration and related matters. He is a trainer in arbitration from the Center for Arbitration Studies and for many organizations of which he is a member. He was a resource person for the Lagos Regional Center for International Commercial Arbitration for several years. His other areas of specialty and interest are in company law and corporate law. For other practice purposes, he is involved in maritime, transnational economic and monetary law, commercial litigation, and interest in oil and gas law and evidence. He is a motivation. His optimum or nihil, either the best or nothing. His SSRN author page can be found on Elvis publications page. Vice Chancellor, sir, distinguished ladies and gentlemen, may I present to you an internationally renowned arbitrator and mediator, a mentor's delight, a teacher of teachers, a law scholar, a law practitioner, a legal social engineer. Ladies and gentlemen, I present to you Professor Chukwuemerie.
Vice Chancellor, sir, the topic of this lecture is Internationalizing Customary Law Arbitration in the World Legal Scene, Dismantling Obstacles, Embracing Change. With your leave, Mr. Vice Chancellor, sir, may I stand on the protocol that you have very ably established? But let me also recognize some persons that are here that have added color, tremendous color, to this lecture. My Lord, the former Chief Justice of Nigeria. It is a privilege to have him here. My Lord, Justice F.F. Tabai of the Supreme Court of Nigeria, is also a privilege to have him here. It is also a privilege, my Lord, to have the Honorable Justice Aguma, the former chairman of the Customary Court of Appeal in Rivers State. My Lord, you are welcome. And my Lord, when I say my Lord, you will understand, gentlemen. I used to say my Lord. My Lord, Mr. Vice Chancellor, sir, I have a bevy of judicial officers here that even if I do no other lecture and I just dance on this place, my Vice Chancellor, sir, I will consider my lecture as delivered. There are many of them from the High Court of Rivers State. There are many of them from the National Industrial Court. There are many others that I'm struggling to see very well, but I'll see you at the appropriate time. Also a bevy of senior advocates who are here. The 19th President of the Bar, OCJ Okocha, JP, JP means justice of the peace. I don't know the other meaning. Some people say juju priest, but I don't know. And then in the order in which they are seated, I have my learned friend. I have my Oga, the man who employed me the first time I started teaching in the Abia State University. He was the dean then. Today, he's a senior advocate of Nigeria of immense proportion. Ifeanyichukwu, S.A.N. And I have my learned friend by his side that my site is failing me about, but my site will get corrected. And then my friend from Enugu State, who is representing the governor of Enugu State, the SA to the governor of Enugu State. Mr. Vice Chancellor, sir, we're talking about internationalizing African customary law arbitration. We're talking about Africa. But the first or precept, if you look at the schools of thought in jurisprudence, if you look at formulations that have been done in the law of torts, in the law of contract, in several areas of the law, you'll find that so-and-so person said this, so-and-so person said this. You will never find an African that the world has acknowledged his scholarship, or if you like, his judgeship, and attributed to him a legal principle or a doctrine. So you find that when you go to torts, you find Lord Atkin. Lord Atkin, gentlemen, is a man that used the scriptures and used it to influence the law and made the law to toe the law of the scriptures when he said in Donua against Stevenson, who then is my neighbor in law? And he answered, it is persons who are so closely and directly affected by my act that I ought to reasonably have them in contemplation, my mind to the act or the omissions that are called in question. The Honorable Lord Denning in USC against Mafoy produced the doctrine that you cannot put nothing on something and expect it to stand. And it is a doctrine that is used all over the world. You cannot put nothing. You cannot put something on nothing and expect it as forming or formulating one. But we have jurists in Africa. We have scholars in Africa, like the late Elias, who was in the academia and became the chief judge of Nigeria. We have had people like Nwabueze. We have had people like Okonkwo. We have had people that have distinguished themselves in the law. We also have judges and justices who have propounded theories and theorems that the law, the world should bow at. For instance, the Honorable Justice Chukwuemerie Oputa, JSC, in the case of Adegoke Motors against Adesanya in 1989, he said about them justices at the panel of the Supreme Court, he said, we are final, not because we are infallible. They acknowledge the human frailties that humankind has. If that or Germany, the entire world would be acknowledging it today as, oh, such a wonderful thing that made common sense and also addresses the law. But because of our self-doubt, Mr. Vice Chancellor, sir, I think that it is the African self-doubt, the lack of confidence in ourselves and the things that we produce that make us that when we produce such things, we don't go ahead to canvass it to the world to know that these things are coming from us. So it is self-doubt, unnecessary superiority complex that the African has. And I'm urging you, my audience today, to come out of that self-doubt. The things I'm going to be saying to you, how the African customary law arbitration can be internationalized. The arbitration that is done in your village, in my village, how can it be internationalized such that the way we can go and enforce other awards made by arbitrators, we can go to the UK and ask the court to enforce the award. We can go to the US and ask them to enforce the award. We can go in the same way and carry African customary law awards that are made in our villages and ask the courts in the UK, in the US, and in other places to enforce those awards. But if we still stay in self-doubt, self-inability, then we will never do that. But God has helped us to do that. Now, in the African customary law, it is even worse. In the African customary law, postulations are made, but it is people are not bold to carry those things outside. In the case of Mojeku against Ejikeme, ladies and gentlemen, there was a culture called Nrachi in Anambra State, where if a man had daughters and he didn't have a son, if he died intestate, that's without a will, all his property will go to his relations. His daughters will go without anything, and his wife will go without anything. That culture came to court, and you can trust the Honorable Justice Nikitobi, my mentor. He said that culture is repugnant to natural justice, equity, and good conscience. It cannot stand. And he made pronouncements. One of them is, he said, in my opinion, it is the monopoly of God to determine the sex of a baby and not the parents. Although the scientific world disagree with this defined truth, I believe that God, the creator of human beings, is also the final authority on who should be male or female. Accordingly, a custom or customary law that discriminates against a particular sex is to sow the least an affront on the Almighty God. The Honorable Justice Nikitobi now said that that kind of custom can no longer live. It's an affront to the Almighty God to say, because a woman is a woman, he cannot inherit from his father. Mr. Vice Chancellor, sir, I'll take you through my journey in arbitration and with arbitration. Mr. Vice Chancellor, sir, in 1993, I had a divine experience, and I'm bold to say so. The Almighty God met with me during the Abiola crisis of 1993, when war was imminent in Nigeria. I went to God and I prayed. I said, if there's war in Nigeria, of course I will lose my vocation, because nobody will hire a lawyer when he's looking for stomach, right? If there's war now, all these my learned friends that are there now will lose our trade. So I prayed God, and God said to me, international commercial arbitration. I didn't know what it meant. And I asked the lawyers that are here now, OCJ is one of them. Then I was a young lawyer. I went asking them, what is international commercial arbitration? And they were honest to me. They said, I don't know what it means. So, but God directed us to the Arbitration and Conciliation Act, and we kept reading. We kept reading. We kept reading. Now, I saw the Coventry University defined what an inaugural lecture is. And it says, it is something of significance in an academic staff member's career at the university. An opportunity to share their achievements in research, innovation, engagement, and teaching activities before an audience of members of the university community and the general public. It affords professors with an opportunity to share their achievements and showcase the difference that their research, innovation, engagement, and teaching is making to the society. So I asked myself, what is my research? What role is my research making in the society? And sir, when God directed me to international commercial arbitration, I was in Abuka Jebo Ilogonwogo. The lawyer said, I will know. But through my friend Eni Apodete, I was directed into George Etomi and Partners. I joined George Etomi and Partners. And I went to George Etomi. The first file that was given to me was a file on arbitration. And they required the filing of an application for stay of court proceedings pending arbitration. And Mr. Vice Chancellor, sir, I did the application. And the Federal High Court here in Port Harcourt did not understand what arbitration was, with all due respect to them. And it's not a bad comment from them. We went to Calabar, it was still the same problem. They didn't understand there was a conflict between Section 4 and Section 5 of the Arbitration and Conciliation Act. Section 4 said, if a party comes for a stay of proceedings, the court will automatically order a stay. Section 5, the immediate section after Section 4 says there's a discretion in the court to order a stay or not to order a stay. Now you know that in statutory interpretation, two sections of an act will have to be interpreted such that the two of them will be valid. How do you do that with these two sections? The Lord God of Israel gave me an understanding to say that we should apply Section 4 to international commercial arbitrations and Section 5 to local arbitrations. That's the only way to save those two sections. And I wrote an article. I was on the academics. And a journal in Switzerland, when they were accepting the article, what they wrote to me, I was wondering whether they know who they are writing to. But you know, the beautiful thing is that today, Section 5 has been done away with, the way we canvass in that article. Then I asked myself, sir, I had also done international commercial arbitration and third-party interests, a call for urgent reform. In arbitration, it is consensual. It is based on contracts between A and B. No third party is involved. But in litigation, there can be third-party proceedings and such things. And I was asking myself, if a third party's interest is involved, how is it addressed in commercial arbitration? Mr. Vice Chancellor, sir, I wrote this article, International Commercial Arbitration and Third-Party Interest, a call for urgent reform. And I sent it, and they published it. I was wondering, do they know who I am? Today, the Arbitration and Mediation Act 2023 now has accommodated third-party interests in section 39 or so and section 40 of the Arbitration and Mediation Act 2023. Mr. Vice Chancellor, sir, I also had looked at arbitration and human rights. That is your area, sir. Human rights is something that is all over the place now. So I looked at arbitration in the context of human rights. How does it work? How does it work in the light of the constitutional provision? Our constitution, gentlemen, provides that a hearing should be public. You hear publicly. But in arbitration, there's confidentiality. You don't say, you don't divulge certain things. We considered that. And when it was published in South Africa, I received raving, wonderful acceptance and reviews. Then I also looked at Mr. Vice Chancellor, sir. I did an article, Necessity as a Model of Trailblazing, applying alternative dispute resolution mechanisms to political disputes in Africa. INEC had invited me to do a paper in a workshop that they were organizing. And they asked, can alternative dispute resolution methods be applied for political resolution of political disputes? And I went to wherever I could find an answer, and I found that, and I did this article, and I hear now that INEC uses that for a resolution of political things amongst political parties, but they are not using it for election results, so they are not using that yet. I also looked, Mr. Vice Chancellor, sir, in Nigeria, it is lawyers that have the right of audience in a court or any place. Now, in arbitration, arbitrators can be non-lawyers, they can be anybody. They can, although those who practice arbitration can also be anybody. So if there's an arbitration and somebody wants to represent an organization or a body, but the Legal Practitioners Act, Section 12, I think, says, no, you cannot represent anybody unless you're a lawyer. But in arbitration, anybody can represent anybody. And we want arbitration to blossom in Nigeria because we want foreign investment. And I looked at this and I did an article, Restricted Rights of Non-Lawyers and Foreigners to Practice Arbitration in Nigeria. Lawyers' Inadvertence or National Legal Policy. It was published and it was wonderful. Now Nigeria has signed Enhanced Trade Investment Partnership. The lawyers know. The MBA is at war with the minister who had done that. We're saying that no, you can't bring other people to come and practice here. But in arbitration, that's done. And so many other things that I have done, sir. Now, I ask myself, which of these areas should I consider in this inaugural lecture? It was some sort of thing for me, but I decided on the whole, sir, to share something that this audience we have something to learn about or something to contribute about. And I decided to talk about African customary law arbitration. Now, I have done an article, Internationalizing African customary law arbitration, and when it was published in the UK, and I received wonderful reviews. So, sirs and madams, that's what we're going to consider. How can an arbitration done in my village or in your village, how can it be used in the UK, in the US, or anywhere else? But before I go into that, let me tell us, sir, that we who are in Africa, we are the ones who are our own enemies. The expatriates recognize arbitration, customary arbitration, but when Africans became the judges, you now found Africans saying that there's nothing like customary law arbitration. And cases abound where they said such things. Now, an American scholar had found long ago that arbitral process has roots deep in history. Resolving disputes by agreeing to be bound by the decision of a third party, trusted by the disputants. Look at what he said. This existed long before law was established, or courts were organized, or judges had formulated the principles of law. Before law as we know it today was started, arbitration had lived with our forefathers in the customary law. But our own judges, wearing African skin, eating eba, they will eat the eba and go and sit in court and say there's nothing like African customary arbitration. Now, why for JCA says so in one case that I have cited here. But, my Lord, let me just go to Oguntande JCA, the man who said what was correct. He says, I do not think that it is contrary to public policy and not in accordance with natural justice, equity, and good conscience for the parties to a dispute to submit to adjudication of a third party in whom the disputants have confidence, both as to his impartiality and competence. The orthodox arbitration, which has been accepted as part of the general law, also operates on such principles of voluntary submission to adjudication of a third party. His Lordship said, I am unable to accept that native arbitration in any way derogates from the exercise of the regular courts of the powers vested in them under the 1979 Constitution. The wife of JCA had said that if you recognize African customary arbitration, then you are now saying that they will be exercising the powers vested in the courts. But of course, Section 274 of the 1979 Constitution recognized existing law before the Constitution was made. African customary law was existing law. But that judge made that error. With all due respect, he was wrong. Now, His Lordship Oguntade said, I found myself unable to accept the proposition that there is no concept known as customary or native arbitration in our jurisprudence. The regular courts in the early stages of arbitration were reluctant to accord recognition to the decisions of our award of arbitrators. His Lordship was arguing the way that you and I would argue. Gentlemen of the audience, are you not arguing that anybody that says that there's no customary law arbitration in Nigeria is wrong? Are you not saying so? You are saying so, isn't it? Anybody that says that there is no customary law arbitration in Nigeria is wrong and is thoroughly wrong. And the man should not come and, with all due respect, sir. Now, another case is Agu against Ike Wibe. The sorry state about this one is that it was even a decision of the Supreme Court. And the lead judgment was delivered by somebody that is your brother and my brother here. But I will not call his name. Now, gentlemen, Agu against Ike Wibe was not purely an arbitration issue. The parties said in their pleadings, for the non-lawyers, please just understand this. Parties said in the things that they filed in court that the plaintiff was summoned. They used the word summoned. And in Africa and everywhere else, when you summon somebody, it means that you have invited him. He's under an obligation to honor that summon. In your village, that is what happens. The native courts, which can be the chiefs and other people, when they summon somebody, that person is under an obligation to come. If he does not come, they will of course, they will know what fines to impose. But in arbitration, you don't summon anybody. Party autonomy means that it is what have been agreed by the parties that will happen. But the Supreme Court now said, oh, that case where somebody will summon somebody is now arbitration. Gentlemen, was it correct? It was not. And they went on and made all sorts of comments and said that in arbitration, for customary arbitration award to be valid, that after the delivery of the award, the parties will now have to come back and say, oh, we accept the award. What I mean is this: if arbitrators come and they say, this is the way it should be, this case is now saying it will not be binding on the parties unless and until the two parties come back and say, we accept the verdict, we accept the award. Gentlemen, do you think that the losing party will agree? It will not. So, but you see, I don't know what happened to the justices, but whatever it was, it happened. Now, but the beauty of it is that immediately after Agwand against Ikewibe, the Supreme Court had another case that dealt purely with wanted land, and they will say, oh, my father had given it to me, blah, blah, blah. Arbitrators met over the matter and said, no, the land belongs to the other party, not you. And the Supreme Court said, because an arbitration had held, whether there was a consent after the award was made or not, that's a post-award consent. Whether it existed or not, as long as there was consent by the parties for the arbitrators to go into the matter, and they have resolved the matter, their resolution of the matter stands firm. That was going back to the arbitration that our fathers knew, and our brothers and our sisters still know in our villages. And Mr. Vice Chancellor, sir, let me stop there in talking about those. Now, about the internationalization process. The Western world enacted, together with us anyway, but you know that in international things, many times we're just there. They have made statutes, they have made international conventions, they have made things that said, look, if let me come this way. There is a body called UNCITRAL. UNCITRAL means United Nations Commission on International Trade Law. United Nations Commission on International Trade Law. That commission made a law, a model law, and said, let all the nations of the earth go and adopt that law and enact it in their own jurisdiction so that it becomes applicable in their jurisdiction, so that the laws governing arbitration will be similar all through the world as much as possible. They did that. That is for English-speaking in Africa, English-speaking part of Africa. Now, in the Francophone African countries,